name is Monica Guisar, and I'm an attorney with the legal department at SEIU. Today, we're going to talk about two laws that were passed by Congress, the Families First Coronavirus Response Act and the Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. These laws were passed to provide emergency relief to workers and businesses in light of the current COVID-19 pandemic. In addition to that, we know that lots of workers who are members of SEIU are on the front lines of this coronavirus pandemic, including immigrant workers. So part of our presentation will include what restrictions may apply to immigrant workers and their families under these two new laws. So the programs created by Congress that workers and their families may qualify for include free testing for COVID-19, emergency paid sick leave and emergency paid medical, family and medical leave, direct cash payments to individuals, and then assistance through new federal pandemic unemployment insurance programs. In addition to that, the two laws also provide additional assistance to businesses, which includes loans to small businesses to assist them with payroll, as well as other assistance for individuals like food assistance, assistance to food banks. There are some homeowner and renter protections in those federal laws. There's eviction protections for residents who reside in public or assisted housing. There's emergency assistance for low-income families. And we're going to talk about today the main relief that exists for workers. And we're going to start first with the three unemployment insurance programs that I mentioned. So the first is the Pandemic Emergency Unemployment Compensation Program. And basically what this does is that it gives workers an extra 13 weeks of unemployment benefits that are administered by the state. They're going to be added on. So if someone loses their job because of the COVID-19 situation, a person can apply for state unemployment benefits and they will be able to receive 13 additional weeks of unemployment, and that's going to be tacked on at the end, and that runs through December 31 of 2020. The next is the Pandemic Unemployment Compensation Program, which provides an extra $600 a week to all individuals who are receiving state unemployment, as well as receiving benefits under the three pandemic unemployment programs. And these additional $600 a week are going to run through July 31, 2020. That means if you're receiving unemployment benefits, you're going to receive that $600 a week additional, and you'll get that through July 31 of 2020. So in addition to that, what the law also did was that it created additional benefits for workers who are typically not eligible for unemployment benefits. And these are usually folks who are independent contractors, like gig workers. And so what the law does is that it created a pandemic unemployment assistance program, which provides unemployment benefits for those folks who are typically not eligible for state unemployment. And those folks will receive those benefits and they will be available through the end of the year, December 31, 2020. And in order to be able to get that benefit, applicants will need to provide a self-certification that they are partially or fully unemployed, or that they're not able or unavailable to work because of being diagnosed with COVID-19, or they have symptoms of COVID-19 and are seeking a diagnosis. A member of their household has been diagnosed with COVID-19. They are providing for care for someone who has been diagnosed with COVID-19. Maybe they're providing care for a child or other household member who can't attend school or work because it is closed due to the COVID-19 pandemic. They are quarantined or they've been advised by a healthcare provider to self-quarantine. They were scheduled to start employment and do not have a job or cannot reach their place of employment as a result of the COVID-19 outbreak. They've become the breadwinner for a household because the head of household has passed away as a result of COVID-19. They had to quit their job as a direct result of COVID-19, or their place of employment is closed as a result of COVID-19, or they meet other criteria that's been established by the Secretary of Labor. And these programs, as I mentioned, are going to run through the end of the year, December 31, 2020. Now, California has its own additional benefits in terms of applying for state unemployment programs. As I mentioned, these 3 new programs related to pandemic unemployment insurance are all going to be administered by the state. So the state of California will administer these new programs. In addition to that, the state of California has provided additional benefits and relief for workers in light of COVID-19. It is important that anyone who is unable to work due to their work closure or the stay-at-home order, or because they are caring for someone, their child, for example, due to a school closure, that you go to the state's EDD website, edd.ca.gov, and you can apply for state unemployment benefits there and get more information. So the law also creates emergency paid leave and emergency sick leave. And so if you can't go to work because you're feeling sick, or you're exhibiting symptoms of coronavirus, or you have a condition that makes you high risk or vulnerable to the coronavirus, or your doctor has recommended that you self-quarantine, or maybe you have to stay home to take care of a family member who's sick or is required to self-quarantine, or you have to stay home to care for a child whose school or daycare is closed but is not sick, you may be eligible for the new federal law, the emergency paid sick leave. That emergency paid sick leave gives workers up to 2 weeks of paid leave if you are unable to work or telework because you're subject to a federal, state, or local order, quarantine order related to COVID-19, or you've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or you're experiencing symptoms of COVID-19 and are seeking a medical diagnosis, or you're caring for someone who's subject to a quarantine order or has been advised to self-quarantine due to concerns related to COVID-19, or you're caring for a child if their school or childcare provider has closed due to COVID-19, or other conditions that the federal government might specify later. So these are all the reasons for which you may be eligible to take this emergency paid sick leave under the new law. Now, in addition to that, California also has paid sick leave. And so an employee who works in California for 30 days for the same employer within a year earns 1 hour of paid sick for every 30 hours worked. And the accrual of sick leave starts on the first date of employment, but the employee can't use the sick leave for the first 90 days of employment. Employers can limit the use of paid sick leave in California to 24 hours or 3 days in each year of employment, calendar year or 12-month period. And the accrual of unused sick time can carry over to the next year, but employers may cap the total accrual to 48 hours or six days. You can take paid sick leave for yourself or a family member for preventative care or diagnosis, for care or treatment of an existing health condition, or for a specified purpose if you are a victim of domestic violence, sexual assault, or stalking. Again, this is the California paid sick leave. In addition to that, Labor Code 246 provides additional protections due to school closures. So an employer with more than 25 or more employees at the same location must allow employees to take up to 40 hours of leave per year to address an emergency at a child's daycare or school. And an employee can use vacation, personal leave, compensatory time, or unpaid leave during this period. So to summarize paid sick leave, you have the new federal law, which you can take 2 weeks paid leave, and that's effective through the end of the year, December 31, 2020. And the reasons are you or a person you care for is ill or quarantined, a school or child care closure, or there's a shelter-in-place order due to COVID-19. Then there's the state of California, which has 3 days of paid sick leave. You can't use it during the first 90 days of employment, and it's specifically for you to use for yourself or a family member for preventative care, diagnosis, care or treatment of an existing health condition or victim of domestic violence. Now, in addition to that, some localities have their own paid sick leave provisions that are even greater than what the state provides. So for example, San Francisco, Los Angeles, San Diego, Santa Monica, they all have their own paid sick leave provisions. So it's important that you look at your local ordinance, your city, to see what they provide. You have the new federal paid sick leave, and then there's the state option. So how do you use your paid sick leave? How is it that you get it? If your employer has rules regarding how to use your paid sick leave, it's extremely important that you follow any rules or protocol that your employer has set up for you to request paid sick leave. If you're a member of the union and you have a collective bargaining agreement, it may also have additional provisions regarding paid sick leave. Request your leave in writing. That's always a good idea to have that, and provide reasonable notice if you can. And it's important to know that an employer cannot retaliate against workers for using paid sick leave. These are your rights under the law. Now, as I mentioned, there's also under the new federal law a family leave, and this includes it protects workers, including workers who were laid off after March 1 of 2020. This new federal family leave only applies to employers with less than 500 employees. You get 12 weeks of leave if you are unable to work or telework because you need to care for your child who's under 18 years old, if the child's school or place of care has been closed or the child care provider is not available. The closure of or unavailability of the child care must be due to an officially declared COVID-19 public health emergency. Now, the first 10 days of that 12-week leave are unpaid, so a worker can use their vacation or paid sick leave, etc. Then the rest of the time is paid at 2/3 of person's pay and capped at $200 a day. And the important thing about this family leave is that it's protected leave. That means that your job is protected, and you can take the leave and you should be able to come back. There is a possible exception for employers with less than 25 employees under certain circumstances where an employer could not allow someone to return back, but those are limited circumstances, but generally paid leave is protected leave. In addition to that, the Department of Labor, the U.S. Department of Labor issued a rule regarding the new paid family and medical leave. It's important to know that the paid family leave excludes most federal government employees. So if you work for the federal government, you are not going to be covered by this law. In addition to that, You do also need to inform your employer that you're going to take this leave. Just like with paid sick leave, it's important that you let your employer know as soon as possible. And according to the Department of Labor's new rule, the worker is going to have to provide information to the employer, such as your name, the date for which you want leave, and an oral or written statement that explains that you're not able to work. Basically, that explains why you are doing that. So, in addition to this new emergency family leave, there's also laws that currently exist that protect workers. One is the Federal Family Medical Leave Act, also known as FMLA, and then in California, we have the California Family Rights Act, the CFRA. And so California employers have to comply with the FMLA or the CFRA if they have at least 50 employees for at least 20 weeks in the current or previous year. And employees are eligible for FMLA and CFRA leave if they've worked for the company for at least 1 year. They've worked at least 1,250 hours during the previous year, and they work at a location with at least 50 employees within a 75-mile radius. Under the FMLA and CFRA, a worker can take up to 12 weeks of leave, this is unpaid, to care for for themselves or a family member's serious health condition. So to summarize the family leave, you've got the new federal family leave, which is going to provide the 12 weeks of job protected leave. The first 10 days are unpaid, but after those 10 days, employers must pay employees at 2/3 of their regular rate of pay, subject to a $10,000 total cap and a 200 daily cap per employee. It applies to employers who have less than 500 employees, and employers who have less than 50 employees can seek an exemption. The worker must have been employed for 30 days to qualify for this leave, and the qualifying reason for the leave is closure of a school or childcare due to COVID-19. So that's the new federal family leave. Then we have the Family Medical Leave Act and the California Family Rights Act, which provides 12 weeks of job protected leave. It is unpaid. California does have a California paid family leave for certain situations, and you can get more information on California's paid family leave at the EDD website, edd.ca.gov. It applies to employers that have at least 50 employees within a 75-mile radius. A worker is eligible so long as they've worked for 1 year and worked at least 1,250 hours during that preceding year. And you can use it for birth, adoption, or to care for a serious health condition for yourself, spouse, child, or parent. So again, requesting family leave, just like with requesting sick leave, it's important to notify your employer. You need to follow any procedures that your employer has set in place. You need to request that from your employer, request it in writing, and to the extent possible, provide a reasonable notice to your employer that you want to take that leave. Now, in addition to these new federal laws, we just want to remind folks that in California, there are additional laws that may protect you if you are unable to work due to becoming ill as a result of COVID-19. Perhaps you have a serious health condition and you can no longer work. There are requirements under California law where an employer is to reasonably accommodate workers who have a qualifying disability. And that's under the law, the California Fair Employment and Housing Act. So if you have a compromised immune system or you're medically at risk for contracting coronavirus, talk to your employer about a reasonable accommodation, including perhaps working from home, or taking a leave of absence. It's best to submit written documentation of any potential disability and request accommodation, and also, if possible, include a healthcare provider's note. Now, there's lots of organizations where you can get more information and resources. I know that SEIU-UHW is going to be sharing this information, but there is an organization called Legal Aid at Work that provides information and a free phone clinic for low-wage workers. Additional resources, you can get additional information from the U.S. Department of Labor, DOL.gov. That's the agency that's going to be enforcing the new emergency paid sick and family leaves. If you have any concerns about applying for unemployment, you should go to the California's EDD website, edd.ca.gov. If you want information about the California state paid sick leave, you can go to DIR's website, dir.ca.gov. If you have want more information about the California Family Rights Act or accommodations for disability, you can go to the Department of Fair Employment and Housing's website, which is dfeh.ca.gov. One of the benefits in the new federal laws that people want to know about are the direct cash payments. And so what the CARES Act does is that it provides a one-time cash payment to individual tax filers. And the payment is going to be, for an individual, $1,200. For a couple who files jointly, it's $2,400. And so you receive $1,200 if you earn $75,000 or less. And for couples, you will receive $2,400 if you earn $150,000 or less. Now, in addition to that, tax filers who have dependents, qualifying dependents, those are children who are younger than 17 years old, you will also receive an additional $500 per dependent. Now, the agency that's going to be administering the tax payments is the Internal Revenue Service, and you can find more information about the direct cash payments on their website at irs.gov. And the IRS is going to base the information on the taxes that you filed for 2018 and 2019. So if you've already filed your taxes, the IRS has your information. If you had a direct deposit already set up to your bank, according to the IRS, they don't need anything else from you. They are going to start processing those payments, and the money will be sent directly to your bank account. In addition to that, for individuals who didn't file taxes, let's say that they are someone who receives Social Security benefits, according to the IRS, and you can find this information on their website, individuals who receive Social Security benefits will be able to receive the direct payment. The Social Security Administration will provide the IRS with the information that it needs to be able to issue those checks. In addition to that, if you have not filed a tax return, IRS recommends filing a tax return to receive payment. So if you haven't filed your 2018 or 2019 tax return, IRS is recommending that you submit that payment. Again, if you have your Social Security benefits, whether it's retirement or others, you will receive that payment based on the information that SSA will provide to the IRS. Unfortunately, millions of immigrants are ineligible for these programs. If you do not have a valid Social Security number, you will not be eligible to receive the direct cash payment. If you are someone who is not a citizen or a resident, and you are authorized to work, and you have a valid Social Security number, and you have filed your taxes, you will be eligible to receive that direct cash payment. However, let's say you are in a mixed status family, and so your spouse, for example, perhaps does not have a valid Social Security number, and you and your spouse typically file your taxes with your spouse using an ITIN, an individual taxpayer identification number. You and your household will not be eligible for that direct cash payment, unfortunately. Uno de los beneficios que van a poder recibir los trabajadores y familias en el país por medio de estas nuevas leyes federales que otorgó el Congreso por causa de la pandemia del coronavirus, incluyen unos pagos directos que se le van a enviar a cada persona quien declara sus impuestos. Entonces, si usted declaró impuestos en el año 2018 y 2019, se le va a enviar un pago directo de $1,200 para un individuo si gana menos de $75,000. Para una pareja que gane menos de $150,000, van a recibir $2,400. Además, por cada dependiente que tenga menor de 17 años, va a recibir un pago de $500 por cada dependiente. La agencia que va a administrar los pagos es el Servicio de Impuestos Internos, o IRS, son sus siglas en inglés. Esta agencia se va a encargar de pagar este dinero directamente a cada persona. No es necesario que usted llame al IRS, el Servicio de Impuestos Internos, siempre y cuando haya declarado los impuestos para el año 2018 o 2019 es suficiente. Y si ya tiene con el IRS y su cuenta bancaria, que le manden su dinero directamente a su cuenta bancaria, lo va a recibir automáticamente a su banco. El Departamento de Servicio de Impuestos de Internos, el IRS, sugiere que si no han archivado sus impuestos, si no han declarado los impuestos para el año 2018 o 2019, que lo hagan para poder recibir ese dinero. Las entregas electrónicas serán depositadas a las cuentas bancarias de la persona que haya sometido esos impuestos del año 2018 o 2019. Para más preguntas sobre el pago directo, puede ir al sitio de internet del IRS, del Servicio de Impuestos Internos, y ese sitio es irs.gov, de chica. Aparte de eso, muchas personas quieren saber si las familias inmigrantes serán elegibles para este pago directo. Siempre y cuando la persona tenga un número de seguro social válido, va a ser elegible para recibir este pago directo. Quiere decir que cada persona quien declare los impuestos tiene que tener un número de seguro social válido. Eso incluye una persona que sea ciudadana, residente legal o persona quien tenga autorización legal para trabajar en el país y tenga número de seguro social válido. Ahora, digamos que hay una pareja que declara los impuestos juntos para su familia. Si una persona de esa pareja tiene número de seguro social, pero digamos que su esposo no, y declara los impuestos con uso de lo que llamamos un ITIN, entonces esa pareja no va a ser elegible para el pago directo. Aparte de eso, si en una familia hay dependientes que no tienen número de seguro social válido, tampoco serían elegibles para ese pago directo.
From Carolina Martínez. ¿Qué ayuda pueden recibir las familias inmigrantes?
Las familias inmigrantes, no importa su estado migratorio, serán elegibles para recibir pruebas para determinar si tienen el coronavirus. Aparte de eso, cualquier persona, no importa su estado migratorio, puede obtener tratamiento médico y pruebas, exámenes médicas para ver si tienen el coronavirus y pueden hacerlo en centros de salud médicos. Aparte de eso, familias inmigrantes trabajadores serían elegibles también para beneficios bajo la nueva ley federal, sea día de enfermedad de emergencia pagadas o el permiso laboral protegido de 12 semanas, donde si no puede ir a trabajar por causa de que han cerrado la escuela o guardería de su niño y si tiene que quedar en casa, le pueden dar 12 semanas libres y su trabajo protegido. Las primeras 2 semanas no son pagadas, las siguientes 10 semanas son pagadas. Aparte de eso, hay días de enfermedad de emergencia pagadas, donde puede tomar 2 semanas de enfermedad pagadas si está enfermo o para cuidar a un familiar enfermo. Esta nueva ley aplica a empleadores que tengan menos de 500 empleados y empleadores con menos de 50 empleados pueden pedir permiso para ser excluidos de esta ley. Aparte de eso, familias inmigrantes, si están trabajando o no pueden trabajar por causa del coronavirus y si tienen permiso para trabajar legalmente en el estado de California, también pueden pedir seguro de desempleo. El seguro de desempleo es estatal en California. Y personas elegibles pueden recibir beneficios bajo el estado de California que varían entre $40 a $450 por semana. Aparte de eso, la nueva ley federal creó un nuevo programa de seguro de desempleo pandémico. El primero es una compensación por desempleo de emergencia pandémica, donde le otorga 13 semanas adicionales de desempleo a los beneficios que recibe bajo el estado, que quiere decir que si usted tiene permiso para trabajar legalmente en este país, ha estado trabajando, pero ahora le han recortado las horas o no está trabajando por causa de la pandemia del coronavirus y solicita el desempleo. Cuando se termine las semanas que le da desempleo el estado de California, bajo la nueva ley federal, esta compensación de desempleo de emergencia pandémica le da 13 semanas adicionales y este programa sigue hasta el 31 de diciembre del 2020. Aparte de eso, hay una nueva compensación por desempleo pandémica donde se le va a pagar $600 adicionales por semana a cada persona quien esté recibiendo estos beneficios de desempleo. Y estos $600 adicionales se van a recibir hasta el 31 de julio del 2020. Finalmente, para personas quienes no son tradicionalmente elegibles para beneficios de desempleos estatales, como personas quienes trabajan por su cuenta o contratistas independientes, van a poder recibir bajo una nueva asistencia de desempleo pandémica beneficios de desempleo y este programa se termina hasta el 31 de diciembre del 2020. Todos estos programas son administrados por el estado de desempleo, el estado donde usted vive, aquí en California. Quiere decir que el Departamento de Desarrollo de Empleo, que en inglés es EDD, es la agencia que se va a encargar de administrar todos los beneficios de desempleo, los estatales y los nuevos bajo la nueva ley federal.
¿Es cierto que las personas retiradas que no hacen impuestos no van a recibir cheques de ayuda?
Personas quienes están jubiladas y reciben beneficios del Seguro Social son elegibles para el nuevo pago directo. La Administración de Seguro Social va a enviar la información al Servicio Interno de Impuestos, el IRS, para que puedan procesar el pago directo a cada persona. Entonces, personas quienes están jubiladas y quienes reciben beneficios del Seguro Social, sí son elegibles para el pago directo.
Will there be protection against ICE raids deportations?
So, Unfortunately, in California, the day after Governor Newsom issued the stay-at-home order, there were reports in the Los Angeles Times that ICE, the Immigration and Customs Enforcement, which is the agency that enforces immigration law, had conducted an early morning raid. I believe that was on March 17. The next day, March 18, 2020, ICE issued an announcement saying that it was going to temporarily alter its enforcement and that it was in light of the coronavirus pandemic, and that it would be limiting enforcement to individuals with criminal backgrounds or someone who posed a substantial public safety risk. In addition to that, ICE confirmed that it was not going to conduct immigration enforcement at hospitals or healthcare facilities or medical treatment centers, and it reiterated that it was going to comply with its sensitive locations memo. And so this is a sensitive locations memo is a guidance that ICE has that indicates that it's not going to conduct enforcement actions like at hospitals and healthcare centers and medical treatment facilities. Since that announcement on March 18th, I am not aware of any immigration enforcement taking place in the state of California by ICE. However, it's important that we stay vigilant. Workers should know, though, that they are, regardless of their immigration status, they are able to be tested and receive treatment for COVID-19 related symptoms. Immigrants, regardless of immigration status, can seek free or low-cost treatment at community health centers. And there are additional resources that you will be provided at the end of this program with different links to community health centers and other resources for immigrants who need medical treatment.
Entonces, ¿va a haber protecciones contra las deportaciones ahorita?
El Departamento de Inmigración no ha dicho que hay protección contra deportaciones por causa de la pandemia del coronavirus. Incluso hoy se reportó que el Departamento de Inmigración deportó a una persona a Haití y que esa persona tal vez tenía síntomas del coronavirus. Entonces no hay alto a deportaciones. Lo que sí sabemos es que el Departamento de Inmigración, que se encarga de ejercer las leyes migratorias, que llamamos ICE, Immigration and Customs Enforcement en inglés, declaró el 18 de marzo que iba a cambiar la manera en que estaba ejerciendo las leyes de inmigración y que básicamente no iba a hacer redadas o detener a personas por causa de la pandemia del coronavirus. Incluso dijo el Departamento de Inmigración que se iban a enfocar solamente en personas quienes tuvieran un récord de antecedentes penales o criminal, o una persona quien ponga el público al riesgo. Pero desde esa fecha, el 18 de marzo, no tengo información de que el Departamento de Inmigración tomado acción o haya hecho redadas o haya detenido o arrestado a ningún inmigrante en el estado de California. Aparte de eso, el Departamento de Inmigración aseguró que la agencia no va a detener a personas quienes estén en un hospital o clínica médica o recibiendo tratamiento en un lugar médico. Así es que hasta ahora no tenemos información que inmigración está deteniendo o haciendo redadas, pero es importante saber y conocer que cada inmigrante, no importa su estado migratorio, tiene el derecho a que vaya y le hagan un examen. Si siente síntomas del coronavirus, puede ir a centros de salud comunitarios para obtener tratamiento gratis o basado en sus recursos.
Para indocumentados no hay nada para nosotros. Se nos hace muy difícil de juntar para la renta porque no estamos trabajando por lo pronto.
Desafortunadamente, las nuevas leyes federales excluyeron a millones de inmigrantes, especialmente inmigrantes indocumentados, que no son elegibles para los programas como el pago directo o los beneficios de desempleo. Pero sí hay organizaciones quienes están asistiendo a los inmigrantes en el estado de California. La organización de Legal Aid at Work tiene una información sobre diferentes fondos y recursos para trabajadores indocumentados en el estado de California. Aparte de eso, hay recursos para comunidades indocumentadas también que se le van a proveer en este programa y diferentes sitios de internet donde puede obtener esa información. Para los fondos en el estado de California para indocumentados, puede visitar la página de internet de legalaid@work.org y ahí hay información sobre sus derechos. Puede visitar esa cita y leerla en español. Aparte de eso, hay una página de internet que se llama inmigranteinformado.com, donde también tienen recursos para inmigrantes indocumentados y trabajadores inmigrantes sobre recursos y fondos donde puede tratar de obtener beneficios.
Next question is, do you have any news for green card applicants who sent their application recently? Will there be delays due to COVID-19?
So the agency that processes green card applications is the U.S. Citizenship and Immigration Services, also known as USCIS. As a result of the COVID-19 pandemic, USCIS closed its offices, and its offices are closed until May 3rd. So under normal processing times, USCIS typically takes around 120 days, that's what it says on its website, to process someone's green card application. But in light of the COVID-19 and the fact, based on the fact that USCIS has closed its offices and it's not going to be open until May 3rd, there will likely be delays in receiving your green card. In addition to that, if it's someone who's applying for a green card and they're doing that outside of the country, the Department of State also announced that based on COVID-19, it was going to stop all routine visa services at U.S. embassies and consulates. And so that happened as of March 20th. So if you're curious or you want more information on the status of USCIS, you can go to the USCIS website, uscis.gov. There is a way there for you to check the status of your case if you need more information. The Department of State also has similar information. You can also check the websites for the embassy or consulate of the country if it's an applicant who's outside of the country to get more information. But unfortunately, in light of the COVID-19 pandemic, we should expect delays.
Next question is in Spanish. Tengo un hermano, no tiene documentos, pero declara a mi mamá en sus impuestos y ella sí tiene seguro social. ¿Él podrá calificar para una ayuda financiera?
Desafortunadamente no. Si la persona a quien declara los impuestos no tiene número de seguro social válido, aunque declara los impuestos y paga los impuestos y lo está haciendo con un I-10 y tiene como dependiente a su mamá, quien es ciudadana o es persona quien tiene número de seguro social válido, desafortunadamente bajo esta ley federal nueva que se otorgó, no son elegibles para ese pago directo, ni su hermano quien está declarando los impuestos, ni su mamá quien es dependiente.
If, God forbid, an undocumented immigrant gets sick and they are not insured, will they be turned away? And since no family members or anyone is allowed to accompany them, how will the family know if they are safe from ICE entering the facility?
So immigrants in California, if they are undocumented, are eligible to receive treatment and testing if they feel sick or are feeling symptoms as a result of COVID-19. In addition to that, there are public programs in California that will treat immigrants. It doesn't matter their immigration status, particularly when you're dealing with a public health crisis like we have here. So undocumented immigrants can get tested and treated at community health centers. You can visit iamerica.org/healthy to get more information. In California, you can visit the website health-access.org/COVID-19-resources-and-information / and you can get information about resources. The California Immigrant Policy Center is another organization that includes a COVID-19 resource guide for immigrants regarding receiving healthcare and treatment. So even under the federal laws, immigrants, regardless of status, are eligible for testing under the at community health centers. And again, you can find those at iamerica.org/healthy. Now, as with respect to ICE entering a facility and apprehending an immigrant, as I mentioned, on March 18th, ICE issued an announcement that it was temporarily changing the way it was conducting enforcement actions and that it was not going to conduct enforcement at hospitals, healthcare facilities, clinics, or medical treatment facilities, and that it was going to abide by its sensitive locations policy, which states that ICE should not be conducting enforcement actions at sensitive locations like hospitals, medical treatment facilities, or healthcare facilities. Since March 18th to the present, I am not aware of any immigration enforcement action being conducted at all in the state of California with respect to any workers or individuals who have been seeking treatment at a healthcare facility. So it is important that all individuals, regardless of immigration status, if they are feeling sick, if they are experiencing symptoms related to COVID-19, that they seek testing and treatment.
So if I receive the direct cash payment or get unemployment benefits, will it count against me under the public charge rule?
No, so it's very clear both in the federal law and just generally in terms of public charge, receiving this one-time cash payment or receiving unemployment benefits isn't going to count against someone who's later applying to become a lawful permanent resident and would not be subject to this public charge rule. So the public charge rule only applies to people who are applying to be lawful permanent residents or green card holders. And the law is clear that these benefits, the direct cash payment, as well as unemployment benefits, do not count against the person in terms of public charge. So there is no concern there.
Si recibo el pago directo en efectivo o recibo beneficios de desempleo, contará contra mí como carga pública.
No, la regla de la carga pública no incluye y no perjudica a una persona quien reciba el pago directo o beneficios de desempleo. La regla de la carga pública solamente se aplica a personas quienes están aplicando para ser residentes legales en el país o están tratando de entrar al país con una visa, y los beneficios del pago directo y del desempleo no son beneficios que se cuentan bajo la regla de la carga pública. Así es que una persona quien tenga número de seguro social válido, permiso para trabajar legalmente en el país, quien es elegible para el pago directo o beneficio de desempleo, lo puede obtener sin problema ni ningún problema en términos de la carga pública. Thank you so much for having me. SEIU is continuing to fight on behalf of all workers. As we know, these Congress relief bills do not do enough to protect all workers. They do not do enough to protect all the workers who are in the front lines, including healthcare workers and home care workers, janitors, security guards, airport workers. And SEIU is fighting to ensure that in the next package that Congress passes to provide relief for workers, that they protect all workers, including immigrant workers, regardless of immigration status. You will receive in the comments a link to a list of resources for you to follow up on. Lots of information. All of this can be confusing and complex, but there are great resources for you to look at regarding the new laws that Congress passed, as well as the laws that exist and benefits that exist in the state of California. And just finally, everything that was provided today is information that was current as of today, April 7, 2020. And this is based only on information and is not considered legal advice. If you have specific questions, it's important that you contact a legal service provider or a nonprofit to assist you with any specific legal needs.